That sucks. Then write a better report. Too bad, so sad.
Statement, I smell marijuana, you look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him.
Man, perhaps, but he's in custody. He's in jail just sitting there. You know, I'm with you. Okay, be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man. Good luck.
Here are unforgettable moments when Judge saved people from evil cops. Michael Jones was standing outside a residence when officers arrived in response to a disturbance call, but as soon as they got there, he began walking away. Under Texas Penal Code Section 42.01, speech alone, even if loud or aggressive, does not constitute disorderly conduct unless it provokes an immediate breach of peace. The officers, however, commanded Jones to stop and put his hands behind his back without giving a lawful reason. When he hesitated, they accused him of resisting and used force to detain him. This was a clear violation of his rights, as walking away is not a crime. The officers were attempting to manufacture probable cause after failing to find a legitimate reason to detain him.
Good morning.
Hey.
How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm gonna have them read, and we're gonna do probable cause to see whether we're gonna go forward or not, okay?
Stuff with me right back there. She's gonna read it again, okay?
Okay, what happened?
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it, but what's he doing? I mean, he's walking away. That's what they wanted, right?
So,
No?
Just losing?
so, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance, somebody's asking him to leave, they're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement, "I smell marijuana, you look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
During the hearing, the defense attorney pointed out that Jones had no legal obligation to comply when he was not being lawfully detained. According to Terry v. Ohio, 392 U.S. 1, 1968, a police officer must have reasonable suspicion that a crime is occurring to justify a detention. The officers had no basis to stop Jones beyond an assumption of intoxication, which was unsupported by concrete evidence. The judge recognized that the situation escalated only because the officers refused to let Jones leave. If they had no valid reason to investigate him further, any subsequent resistance was irrelevant. This made the entire arrest unlawful, and the judge knew it.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating, a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave, so cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to...
Yes, Lord.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only,
right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them.
Yeah.
All right, man. Good luck.
Thank you.
Unless you...
I didn't hear what happened.
After hearing both sides, the judge ruled that there was no probable cause and ordered Jones to be released. Under the exclusionary rule established in Mapp v. Ohio 367 U.S. 643 1961, evidence obtained through unlawful means must be suppressed. The officers had no legal standing to arrest Jones for interference when they lacked lawful authority to detain him in the first place. The judge even warned Jones to be careful in the future, acknowledging that bad policing can make innocent people targets. This decision protected Jones from wrongful imprisonment and sent a message against abusive police tactics. Just like this incident, here's a moment when a judge saved a man from corrupt policing.
We need to have like a workshop on how to write ORs, man. For real. Everything in this office report is conclusory, suspicious, aloysius,
A Texas man, Keon Shaw, found himself in court facing charges of fleeing a police officer, carrying a potential 6-month jail sentence and a $2,000 fine. The arrest stemmed from an officer's claim that Shaw was driving at an unsafe speed above a 35-mile-per-hour limit. However, under Texas Transportation Code, Section 5, 45.351, an unsafe speed must be determined based on specific conditions like weather, traffic, and visibility, not just a vague assertion by an officer. The police report failed to specify Shaw's actual speed, making the claim conclusory and legally weak.
Shaw,
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that?
During the hearing, the judge quickly recognized the report's flaws. The officer's account lacked crucial details, like how much Shaw exceeded the speed limit. Under Texas Transportation Code, Section 543.006, a traffic citation must specify the offense clearly, ensuring a driver understands what they are accused of. Yet, the officer's report merely labeled Shaw's actions as suspicious without legal backing. This raised concerns about racial profiling rather than legitimate law enforcement. The judge saw through the weak probable cause and refused to allow vague accusations to justify the arrest.
So
Anything illegal with that? You know?
I believe it would just be the speed limit would be the point at which the officer.
It's a conclusory statement. We need to have like a workshop on how to write ORs, man. For real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure.
terms.
Let's do this. I'm going to have him because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. Okay.
A few moments later.
Okay. Come on up, Mr. Shaw. All right, so we're going to do Shaw now since he's, yeah. All right. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life. All right?
Yes, sir.
All right, man. Good luck.
The prosecution had no additional evidence to justify the charge. Seeing this, the judge ruled there was no probable cause and dismissed the case. The judge warned Shaw to stay careful on the roads, but more importantly, he refused to let an officer's vague and conclusory claims dictate the fate of an innocent man. If the judge had not intervened, Shaw could have faced unjust prosecution based on an officer's assumptions rather than clear legal violations.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point where it is.
I'll check the.
A man was charged with driving while intoxicated after an officer claimed he caused a crash. Under Texas Transportation Code, Section 550.021, a driver involved in an accident resulting in injury or damage must stop and provide information. However, the officer's report initially stated the accident occurred on US 50, but later changed it to US 59, raising serious credibility issues. The judge quickly caught this inconsistency, questioning whether the arrest was even valid. Since US 50 is not in Harris County, the officer's shifting statements suggested possible misconduct. This error cast doubt on the entire case, putting the officer's integrity in a question.
Mr. Lozano, come on up.
Rear end accident on 59. Gonna take advantage. He doesn't get prior.
Any prior DWIs?
I don't believe he's got any priors of any kind. No.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The real witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard fields of writings were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what they said it happened though.
Where is it?
It said US 50, that's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the DIMS further says, during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas, but counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS, they just put 59.
Right.
So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point it is.
I'll check the OR and see if they clarify in the complete OR.
Yeah, this is the way on.
And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas 77004.
So is 50, it's not in Harris County?
He switches between 50 and 59 in the offense report, Chief.
I know, probable cause.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to, he's great.
The officer claimed the driver showed signs of intoxication, listing slow speech and disorientation as evidence. Under Texas Penal Code Section 49.04, a person commits DWI if they operated the vehicle while intoxicated in a public place. The officer also conducted field sobriety tests, alleging the driver failed multiple tasks, but the driver denied drinking that day. The officer then sought a blood warrant after the driver refused a breath test, but the contradictory accident location weakened probable cause. The judge, seeing the flawed report, focused on whether the case had legal grounds to proceed. Without reliable evidence, the case appeared built on questionable claims rather than lawful procedure.
Listen to, he's great. He'll help you out whenever you need, you know? All right, man. Good luck.
Excuse Judge? Yeah. All right, I'll meet you in the hallway. Okay.
The judge dismissed the case, and in this next case, a man was pulled over for speeding, and officers claimed they saw him trying to hide something near the center console. Based on this, they ordered him and his passenger out of the vehicle. As the passenger stepped out, the officer then claimed to have seen a plastic bag with a green leafy substance that smelled like marijuana. However, there was no clear indication in the report that the bag was directly tied to the driver. Under Florida statutes section 893.13, mere proximity to a controlled substance is not enough to establish possession. There must be evidence that the accused knew of its presence and had control over it. The defense attorney pointed out that the passenger was the one who ran away, which made it more likely that the marijuana belonged to him rather than the driver. The report failed to specify where exactly the drugs were found or whether they were in the driver's immediate control.
What's going on?
Judge, I'm here on docket for Mr. Nathan Ria, Judge. I'm seeing if you'll revisit probable cause in this case.
You said Ria?
Yes, sir. RHEA, Judge.
Okay. Is it on docket today?
Yes, Judge, it's my understanding.
Jail, maybe jail docket. I see, yeah, it's jail docket.
Yes,
Okay.
sir.
All right, you ready?
Yes, sir.
Go for it.
So, on December 29th, 2024, the officer observed the defendant's vehicle traveling 91 miles per hour in a 50-mile-per-hour zone. A traffic stop was initiated, and the officer observed the driver leaning over the console, trying to conceal something next to the console in the front passenger seat. The driver and the passenger did not see the officer as he was standing near the driver window, where the officer observed the driver have his hand between the front seat and the center console. The officer ordered the occupants out of the vehicle and observed a plastic bag containing a green leafy substance with an odor of marijuana. As the front passenger exited, and the front passenger immediately took off running, and the defendant, the driver of the vehicle, stated he only knew the passenger to be named Junior. The weight of the marijuana was 0.3915 ounces.
Judge, looking at the totality of the circumstances, the state has not been able to allege enough probable cause that my client knew or intended that there was marijuana in his possession. I understand that the allegations say that there was some type of furtive movement, but my client yielded to law enforcement show of authority, and then gave law enforcement his identification. The passenger ends up leaving law enforcement. He stays there, and again, there's not enough to establish that he knew or intended that there was weed in his car. The allegations also don't, pinpoint where the marijuana actually was. So this was unbeknownst to my client, Judge.
So he comes up, officer comes up to the car, and he sees him trying to conceal.
Yes,
right?
I don't think that, I believe the allegations say that that's what the officer maybe seems to believe, but after further review, there's nothing that says that's definitive or that's even probable cause. For all we know, he was rummaging around to give him his ID, which he did. That's why he got picked up.
No, but he says he's got a plastic bag and he's trying to put a plastic bag behind the console.
Because, Your Honor, they found his hand between the front seat and the center console. They observed his hand in between the console.
There was a plastic bag too?
It says that they observed a plastic bag containing the green leafy substance. Yes, Your Honor. And that was after the passenger exited. So when they walked up, they saw him with his hand in between the console and the front seat, where they observed him trying to conceal something.
So, Judge, in the DIMS, it says, quote, as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance. The way I'm reading that, Judge, is that's more attributable to the passenger and the alleged marijuana that was near his person than it was my client. Again, the rummaging around, Judge, I don't think there's enough of a nexus to establish that. My client yielded to law enforcement's show of authority. He gave law enforcement his ID. While he's standing there submitting to law enforcement's show of authority, the guy with his hands up with the marijuana that's around him leaves. So if anything, this should be attributable to the passenger.
Saying that the weed is the passenger's client, not your client. That's what you're saying.
Yes, and based on the allegations, Judge, there's not enough probable cause that attributes my client knew or intended that marijuana was in his possession, when everything just as much points to someone who ran away from the cops.
Read the DIMS again, and then who is the one who's allegedly hiding things? Is it?
It's the driver, Your Honor, which is the defendant. Right. The officer said the officer observed the driver have his hand between the front seat and the center console, and previously...
Okay, wait. So between the front seat
in the center console, and the officer said, I observed the driver leaning over the console trying to conceal something next to the console and front seat passenger. And that's where he observed his hand in the front seat, between the front seat passenger and the console. So the officer observed him trying to conceal something. And all the DIM says in regard to the passenger and the marijuana is that as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance smelling of marijuana. It doesn't say anything in regard to it being in the solely in the passenger's area, because it said previously he was trying to conceal something.
Again, so my apologies, counsel. Judge, if I may.
He's actively trying to conceal a plastic bag.
Your Honor, so with this situation, when we were briefly speaking, allegedly this driver and passenger don't know each other, but then in this situation, should this person, the defendant, be pulled over for speeding, one would think he'd keep his hands 10 and 2 and not be trying to conceal something, so that's where we're at. And if you didn't know that didn't know the passenger, didn't know that they had the marijuana, didn't know anything about the marijuana, why are you concealing? Why aren't you keeping your hands at 10 and 2?
The officer's claim that the driver was concealing something was used as justification for further investigation, but the judge wasn't convinced. Under Florida case law, furtive movements alone are not enough to establish probable cause unless they are combined with other clear evidence of a crime. The officer's report was vague and didn't explain exactly where the marijuana was found in relation to the driver's supposed movements. If the driver had truly been trying to hide a plastic bag, the report should have specified that officers found drugs in the same spot he was allegedly reaching for. Instead, all the report said was that they saw marijuana as the passenger exited. The judge called this out, saying, "It's not that hard to write in the report, I saw weed where I found his furtive movements." Without a clear link between the driver and the drugs, the state's case was weak.
Judge, anytime somebody's driving, again, I think there's a reasonable inference that goes just as much to my client was trying to go through his belongings, give law enforcement the correct identification so that he could submit to law enforcement show of authority. Again, just because it says concealed doesn't mean that there's enough allegations that actually substantiate that anything was concealed. If anything—
No, but is that enough for him to continue and to investigate further? Right, his allegation is, I come up to the car and I actively see someone trying to conceal something. So at that point, I'm going to investigate further.
My issue is not, law enforcement had the right to further investigate the case. We understand that my client was speeding, Judge. My issue, though, is that they're saying that the front seat passenger is getting out of the vehicle and then he sees weed as the front seat passenger gets out. My client is already—
So who do they both have weed? Is that what happened here? Do they both end up with—
My understanding, Judge, is that there's enough probable cause that actually goes toward the passenger being in possession of the—
Did they find weed where he was trying to conceal whatever he was trying to allegedly conceal?
The allegations are not clear about that, Judge, which is why—
Admittedly, they are not clear about that, because all it says is that as the front seat passenger exited, they observed the plastic bags. But previously, they did say—
Where?
It does not say, Your Honor.
That sucks. Then write a better report.
It does, but they did say that concealing something.
I need to know, where is the weed in the front seat passenger?
All right, there are enough affirmative links still, because he's the operator of the vehicle and is within his wingspan, and they saw the previous furtive movements being made to draw the inference of $1. So there's enough affirmative links between him and the contraband for a probable cause.
I don't work on hunches.
It's not a hunches
here. I mean, it's not that hard to write in the report. Well, I saw weed where I found his furtive movements. You know?
Yes, Your Honor, they didn't clarify that, but they did see him concealing.
Then, too bad, so sad. Sorry.
I will say, Your Honor, this did just happen 2 days ago. If we could wait to get the offense report, maybe he articulated it.
No, I mean, he's in custody. I don't want to wait 2 days because he's in custody. If he was on bond, perhaps, but he's in custody. He's in jail just sitting there, you know? I'm with you. Okay.
Thank you, Judge Fletcher.
Since the driver was still in custody, the judge wasn't willing to wait for a better report. Under Florida rules of criminal procedure, a person in custody must have a determination of probable cause within 48 hours, or they must be released. The judge acknowledged that if the driver were out on bond, there might be time to clarify the report, but in this case, he wasn't going to let someone sit in jail based on weak allegations. He ultimately sided with the defense, making it clear that law enforcement needed to do better if they wanted to justify keeping someone locked up. When you think you've seen it all, here's a crazy incident where cops wants to destroy someone.
Listen, you don't need to say a word.
Good morning, Mr. Bio. You speak English, right?
Yes.
Okay. Shh. All right, Mr. Bio, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which it is. All I know is that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
The prosecution alleged that Mr. Bio violated a protective order by going to the residence of a protected individual, Mr. McWilliams. Under Texas Penal Code, Section 25.07, a person commits an offense if they knowingly or intentionally violate a court-issued protective order. However, the defense quickly pointed out a major flaw. The so-called protected residence was not McWilliams' home. Both McWilliams and his ex-wife, Shannon, confirmed that he had moved out before the alleged violation. Without this key element, the charge had no legal ground.
Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. Complainant went to the residence because his ex-wife had called them and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said a friend. Complainant then heard defendant's voice in the background and went over to the apartment. Complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believed that the defendant would be watching his and his ex-wife's children, and that's why he went over to the apartment. Complainant is the same complainant from a pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened is
I think it was punching in the face with a closed fist.
once, twice, thrice?
2 to 3 times, it looks like, Judge.
Okay.
And I can give some excellent background that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, and I've got a copy of that, Judge, if you need to see.
And did we order him not to have contact with this person?
Yes, but that's not the basis of the new charge. And so if we delve into the state's filed information, which is also the basis of the allegation he violated, well, imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that McWilliams has moved out of that residence as of the date of the first alleged assault. And McWilliams has told them that. They have been unable to reach McWilliams as of recently. But in the writ call information, McWilliams confirms, I moved out that day and do not live at the address that's at issue in this VPO case. If you look at the filed information in that VPO case, it's a necessary ingredient of that allegation that McWilliams live at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, Chair. Oh, no, not the protective order. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the lease.
He's still not supposed to have contact with this person.
He's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Bio.
what's the ex-wife's name?
Shannon.
Okay, so
And we both spoke to Shannon a few minutes ago.
and Shannon has how many kids with Mr. Bio, or do they have kids or no? So whose kids are they? McWilliams?
Williams and Shannon's children.
Okay.
I think there's 2.
And so what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe in. He did not go to the residence of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on, my argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress, the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams' address.
Is that his address? Yes or no?
That is no longer his address, Judge.
Okay.
When that was filed, I imagine that was the original apartment, but on the
Because a lot of
day,
times they never updated, they just put the original apartment where it happened at, and they always assume that it's this, and, you know, just,
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident, and he told
Okay.
me he moved out. I believe that Shannon is the only name on the lease.
for the violation case, where is he alleged to have gone to?
He went to the address that's listed in the original MOA. So he went to the Spring.
Spring Cypress.
Right.
That's right.
Okay.
But
what he's saying is that this person no longer lives there.
Despite the accusations, it became clear that Mr. Bio had not even interacted with McWilliams. Texas law requires that probable cause exist for each element of a crime to proceed with charges. In this case, the prosecution's claim hinged on McWilliams still living at the apartment, which he didn't. Shannon also confirmed to both the state and defense that McWilliams had moved out, making it impossible for Bio to have violated the protective order. The judge, recognizing the lack of evidence, immediately questioned the legitimacy of the charge.
well, that's what McWilliams told the state, and that's what Shannon has told both the state and myself, and that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives, and McWilliams is not living at the Spring Cypress.
The problem is that we also have this address there because he could always go back.
Well,
He may not live there. Maybe he lives there partially. Maybe he comes and goes.
But what us was he was kicked out.
Also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone call, certainly what was represented to me. And
what do you want?
Well, I want no PC to be found on the violation of protective order charge, because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know, on this matter,
I gotta think, it's expressed in the order. In the order is that address was PC, but the actual information.
I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
the address in the order, who was staying?
The defendant was staying at the address in the order.
In this
In the
protective
original
order.
MOAB, Spring Cypress.
Okay.
The defendant was staying there. But I will say in terms of PC, I'm going to defer to the court on this matter.
May I just read that little blurb of the information that I think is important for the court to hear? May I take a, yes, cheat and steal y'all's computer? Go ahead. So,
Do we still have a problem with him trying to communicate, though?
no, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. Like, he initiated the contact in the situation.
And what's alleged is, and it's the last clause, well, maybe two clauses, it says, a place specifically described in the order, to wit, the residence of a protected individual, namely Mark, and it should say Mick Williams, but it says Mark Williams. So it's, in order to meet this charging document, it would have to be that gentleman's residence, and he does not reside there, as by his own representation to the state. And so I'd ask that, and I know it's a very unique situation.
How do we go forward, though? If I find no PC, how do we go forward? No.
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr. McWilliams.
How do we know that this isn't going to happen again?
Well,
I will say, I'm not sure where Mr. Bio will be staying if he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address will no longer, it won't even belong to any of them as of tomorrow.
Judge Fleischer wasn't fooled by the prosecution's weak arguments. Under Texas Code of Criminal Procedure, Section 17.15, bail decisions must consider the safety of the community and the likelihood of reoffending. The judge noted that McWilliams himself had been the aggressor, breaking windows and escalating the situation. Instead of blindly siding with the state, the judge saw through the inconsistencies and ruled that there was no probable cause for the violation charge, preventing an unjust prosecution.
Do we do a no contact with both?
We would do no contact with the witness, with Shannon, but I would ask no contact with Mr. McWilliams.
You are now in a relationship with Shannon, right?
That's right, Judge. But yes,
so
I've instructed him, just let me answer for him, Judge. But he is in a relationship with Shannon, that's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so long-term, we think there'll be issues with case one even. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think, obviously, no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate, and that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
Have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run a new check on it.
Do you see? I mean,
and I don't want to be incorrect, but I think he's got violent history with Shannon, but maybe Judge, when you get to be my age, it's hard to remember all the details, but I think I recall that, but maybe I'm mistaken. I don't want to represent something inaccurate.
You have inherited a dangerous situation. And Mr. Bio, you need to be very careful. You know, if you are in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. You know, it's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. we can always help you out as well. I'll find no PC on the violation of a protective order, but just be careful, because there are a lot of vindictive people in this life that will they'll try to make your life a living hell. And you being on bond in this case, they can do that. They can say, hey man, he's doing this to me, he's threatening me, he's doing that. And if an officer doesn't know any better and they come up and they see that have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay? Okay, so I'll find no PC on the,
And I think Judge Wood,
on the violation case. And I'm not gonna revoke your bond on the original assault case, Mr. Bio, but you gotta be careful, man, you know?
and Judge, I think you should also have him give his updated address to pretrial would be appropriate as well.
Okay. And I think there's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for, McWilliams, so I don't know how we're going to handle
Well,
that.
I think the protective order does say any address where McWilliams does reside. So whether or not, I guess that'd be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's going to now be, Okay.
You do understand all that?
Do you have any questions? Just be careful. Life's too short to live either in a 6x9 box or be 6 feet under, because you got other people that have just be careful. All right.
Thank you, Judge.
Good luck. Good luck, Mr. Bio.
Before closing the case, the judge issued a serious warning to Mr. Bio. Texas law recognizes that false accusations can lead to wrongful arrests, which is why courts must scrutinize evidence before issuing rulings. The judge reminded Bio that being in a relationship with Shannon put him at risk of further false claims, advising him to be cautious and even consider getting his own protective order. By refusing to let the prosecution railroad an innocent man, Judge Fleischer proved that smart judges can stop corrupt tactics before they ruin lives. Like and subscribe for more police cam stories. Watch the next recommended video click to watch now.